begin, before I commence, let me remind you, this revision lecture, quite contrary to what some students believe, is not a replacement. It's not a replacement for the materials from your proper lecture. Okay? Do not expect that you just cover this 50 or 60 slides and then you will do well in the exam. Okay? This lecture, when we go through the mock questions, the purpose is only to go through with you how to tackle and the structure. It is not to replace your substantive knowledge. In fact, you will see when I go through the questions, some of it I'm only in very brief bullet points. Okay, because when you look for the substantive material, you should go back to your course manual and our PowerPoints. Okay, this is just to make sure that we are not on any illusions. Okay, because this we only have 50 odd slides, substantive material. We cannot replace your 300 odd slides or your course manual. Okay, everyone clear on that? Of course, when we go through the materials, if there are points that you are still stuck, I'm happy to answer them. But of course, I cannot put 300 slides here that you can understand. As usual, I would say we will finish a little bit early, and I will stay until the time to answer any questions you may have. Anything you are still stuck on, I'm happy to answer. Just as long as you understand this is only for structure and how to tackle the questions. Okay? I will keep on using this microphone while I'm standing here. If it's not clear, please let me know. Is it amplifying at all? Is it any better? No? That's the closest I can have doing that. Okay. Okay, if you can't hear me clearly, let me know. Is this good enough? Not good enough? Not good enough. Okay. Well, while I'm standing here, I can still. Okay. Is this better? No. Not that hard. Okay, I have to do this. Is that correct? Okay, I see knots there. I will comply with your request. Okay, now, let's get on. You're welcome. Or if you can't hear it, there's no point, right? Okay, now, first question. I've got my revision manual for the purpose of looking at the question, but I think you have the same topics. Okay. First question is about pre-action considerations. Okay. Let me know if my question is different from yours. I'm told they haven't revised it for 2 years. So the first question should be, you are consulted by Elaine Cole, is that right? Yes. Elaine Cole, concerning a loan of $2 million that she had given to Candy Mann. This was an interest-free loan, so no need to pursue interest for the loan itself for 6 months. Despite Elaine's request for payment, Candy has failed to do so. Before issuing the writ, what pre-action considerations would you attend to on behalf of Elaine? Wow. This can't be assignment questions, right? Okay, so you have a little bit of tips from there as well. Okay, so areas that need to be considered. Okay, so what you should think about in such a question is what areas. Okay, when you have, I think when I go through this topic with you, I reminded you there may be 30, 40 bullet points from your course manual, right? If you think about the issues to be considered. The smart way to do it is to actually categorize it. To categorize it into general headings so that it doesn't just look like scattered bullet points, or even if you put it into sentences, doesn't look very scattered and unorganized. So you briefly put them into general headings such as cost issues or firm's capability issues, things like that, like internal considerations about the firm or the solicitor, and maybe your first consideration, because without that, you probably shouldn't act anyway, right? So try to arrange it that way. Before to apply, okay, second point there. Instead of just reading out your suggested answer, which you already have, right, in your revision manual, I'm trying to give you more pointers for you to consider how to improve an answer. Okay, when you apply on the facts, apply. Okay, a lot of people answer the questions, a lot of students answer the questions just by listing out, although they are smart enough to not use bullet points, but in sentence format, they just list out one by one. That is not application. Okay, what kind of, what nature is it? What area of law? That should be easy enough to apply, right? Especially since you've done all the subjects. So before to apply, do not invent facts. Right? If you are told it's linguistically long, it's linguistically long. Don't suggest otherwise. Don't go contrary to the facts. Okay, here it's very easy because we told you, for example, this question, we told you it's linguistically long. If the question does not say so, doesn't say there is interest, do not invent. Unless you have some hint. Okay? You can, however, consider scenarios where the difference is don't assume. Okay? If you have to apply, okay, I really need the scenario or alternative to go on with my answer, then use the magic word if, and this goes with your other subjects as well. Do not invent facts and do not go contrary or against the facts that you're given. Okay? Logical flow. Think of a logical order. When, for example, I just suggested to you that you start from looking internally at your firm or the solicitor to look at the capacity, capability, and experience, etc. Right? You go from internal and then you go from step by step. Okay? You don't, for example, you may not consider, you don't really blab on about evidence before you look at the nature of the case, right? It's a logical flow. Well, this is already like answers to you. Okay. Now, whether to act for this client, so we've looked about opening up a case for the plaintiff, to ensure the papers are in order, etc. Interview the plaintiff, going through the paperwork and taking instructions, checking whether other solicitors are acting for the same client on the same matter, ensure the firm is capable and competent to act for the client, confirm no conflict of interest. Okay, these are general stuff. Look at the case itself. Okay, identify potential causes of action, breach of contract, recovery of loan, negligence, personal injuries, product liability, etc. What's the cause of action? Okay. Parties involved, Helene as plaintiff and Kenny as defendant. Check limitation period. Because this, when you look at it, these are stuff or pointers that you have to look at before you go further on any other steps. Right? If you decide the limitation period, for example, has already expired, and if you think there is no excuse, it stops there, right? So these are general framework issues that you have to consider first. Identify the remedies sought, okay, and likely venue for the trial. Here we have a loan of $2 million, right? So naturally you would think about district court, because the maximum now is 3 million, right? General things like that. Complexity of the case. Is there any need for counsel? Is the law complex? Please do not take any photograph yet. Complexity of the case. Any need of the counsel? If the matter, I guess counsel issues is, just look at the complexity. You may not need a counsel from the beginning, right? So you have to look at when it arises. Can the client afford counsel, engaging in counsel? Is there anything for split trial? Do you think there's anything for split trial here? No, right? It's pretty simple, right? So remember, I told you, not every case, not every consideration applies to every case. My example to you was about, remember, Practice Direction 18.1. Remember? That only applies to personal use cases. Right? So things that do not apply in your present case, do not use them. Or alternatively, some students are uncomfortable. To give you an example, right, in other subjects as well. Remember your obligations, tort? Anyone still remember your tort? Okay, about traffic accidents. Now, general negligence, I know I sometimes sway, but we have enough time, okay? But to give you an example, when you answer questions in a negligence case, in duty of care, do you always use the power to establish the duty of care for that category? Anyone can answer me? Apparel and Dickman. No one knows? Or what is it? Nobody remembers. Okay. In your I know, I apologize, sometimes I sway to other subjects. But my example to you here is, if something do not apply to your question, do not apply it, right? It is not applicable. Caparo and Dickman, for example, in your duty of care, in negligence cases, you only use that test, the 3-stage test, when it's a new and unestablished category. Now, if anybody remembers that, right? For established category, you do not mention Caparo and Dickman. Do you understand what I'm saying? No, I've got everybody lost. Have I got everybody lost? Okay, back to here. Eve, remember your Practice Direction 18.1 about pre-action letters, medical evidence. Now what I'm trying to say is that for factors or considerations that are not applicable, don't feel obliged to mention it. Okay? Do not talk about, my example is 18.1, Practice Direction 18.1 on personal injury cases. Do not apply that to our loan case. Is that understood? Okay? Possibility of a split trial may not even be applicable here. So if so, do not use it. Right? The only applicability of that is unless the defendant admits liability with quantum to be assessed in one of those forms. Right? As to evidence and related issues, ascertain what witnesses are likely to be needed. Do you have the contacts? Are they going to be willing? Are they likely to be willing to attend as witness to support your case? Documentary evidence that needs to be collected. Advise clients to keep original documents for the purpose of discovery under Order 24. Cost and money matters. Okay? Advice on all stages of litigation. Okay? How long the litigation is likely to last, what costs are going to be involved. Now, although not every applications, interlocutory applications are going to be applicable. Some are mandatory, right? Filing witnesses, witness statements, going through discovery stage. Okay? Pleadings, discovery, witness statements are going to be mandatory. So you have to advise the client on those, plus the trial. Estimate cost of the whole action, if possible. Advise on rates and charges. So you have to probably advise on a band, a spectrum, right? Depending how the other side's conduct is. Advise on liability of cost, whether or if client wins or loses the case, what are the cost implications? Consider whether the defendant himself or herself in this case, can be, is worth suing. Right? Whether it's creditworthiness, property checks, etc. Okay. Any risk of dissipation of assets, so that you would advise the client to apply for a waiver injunction. As with all civil action, it's the legal representative responsibility to advise or suggest the client to consider ADI. Okay? And then also a letter before action. Okay? As a, well, it's sort of a courtesy, but it's almost expected nowadays. I'm giving the pointers to you, Anna. Now, please avoid bullet point lists. I mean literal bullet points. Every time I still receive answers, some answers in bullet point form. Please avoid that. Do not answer questions with questions. At least don't say, what if, don't phrase your answer. At least phrase it in the way like check if the client or check if the defendant is worth suing. But don't give me questions like, is the defendant going to be worth suing? Can we enforce the action? Or can we enforce the judgment? Don't give me really questions in the literal sense. Am I clear? Okay. Students tend to fail to apply the facts, or some students fail to apply the facts. And that's exactly what I'm saying. The relevant considerations, talking about practice direction or elements of negligence when we're dealing with a contractual claim. Okay. Now, as this is part of your assignment, I won't go so much in depth, but you get the general idea, and I've already given you the common pitfalls. Are people sort of generally okay with it? Are you all okay with it? It's pretty simple. Okay? Now, if you really have got some query, you can still ask me. If it's a general one, I'll try to answer it. Now, moving on to question 2. Outline and explain the principal methods of service of the writ on a defendant in Hong Kong. So what do you need to cover in that question? Concept of service, so you have to define service. And then you have to talk about the writ. If I were you, I would briefly mention what has to be attached to the writ, served together, but only briefly. Okay, don't spend a whole big paragraph. Principal methods of service is what you're concentrating on. Okay, notice that we have our question says principal methods of service of the writ. Now, why do we say principal? Because if we venture into substituted service, there are many ways in which you can do substituted service. So we want you to concentrate on the main methods. Okay, so you define service. What is service? Delivery of legal papers upon a party to ensure all other parties has knowledge of the existence and progress of the legal proceedings. Consequence of non-compliance, service will be held to be defective or invalid. If you're relying on that service as a basis of interlocutory application or going onward with your case, then any judgment or order you seek or you obtain may be set aside. How can you prove service? You can prove service by affirmation of service. Okay, I've shown you one during my lecture. Okay, so what that normally does is just normally a clerk of the firm just making an affirmation stating how those legal documents have been served. Right? That's it. But it's okay. When you go in your exam, you don't really have to say, oh yes, you have to attach this and that. Just say that by an affirmation of service, that can be a proof of service, that's okay. But you don't have to, we don't really expect you to go into details of saying you attach the slip of the registered post and or this and that. No. Okay? The writ, when served, you have to serve what we call a sealed copy of the writ, meaning it must have been issued. Remember the stamp? Okay? Sealed copy of the writ must be served within the period of validity, which is 12 months or a year from the date of issue. Must be accompanied by a form of AS, which we also call Form 14. The acknowledgement of service is done. A form of admitting the claim. If liquidated claim is Form 16. If unliquidated is Form 16C. Now going on to methods of service. What's the most preferred method? Personal service, because you're sure you got the person, right? As simple as that. So personal service effected by delivering a copy of originating process personally to the defendant. If defendant refuses to take the document, can leave document as near as possible within the defendant's possession and control. Service is deemed to be effective on the date of that personal service, on the day you served it personally upon the defendant. Next best way, as we can say, is the postal service under Order 10(1). I do not tend to read out during my PowerPoint on the rules, but please remember to cite you must cite the rules. Postal service by registered post to the defendant's last known or usual address in the jurisdiction. Because if you want to serve out of jurisdiction, you have to obtain leave under Order 11. Remember? So here, postal service, normal postal service means address in the jurisdiction, not including service out. Inserting into letterbox of defendant's last known or usual address in a sealed envelope addressed to defendant. No matter whether you use A or B, method A or B, date of service is deemed to be effective on the 7th day after the writ is posted or inserted into the letter box. Postal service not effective if it can be shown later that the plaintiff knows the defendant no longer lives at the address to which the writ is posted or by registered post or inserted into the letter box, or that there is evidence suggesting or proving that the service has not been effective to bring notice of the proceedings to defendant. Now, one very important thing is that the defendant must be within the jurisdiction of Hong Kong at the time of service and must have actual knowledge of the writ. If otherwise, it would be defective service. If defendant already tells you that yes, there is now a firm acting for me, then you can serve those documents on the defendant's solicitors. Okay. Either the defendant has told you that yes, there is this firm of solicitors ABC and Co. acting on behalf of me now, or ABC and Co. tells you that yes, we've got instructions to be able to accept service on behalf of the defendant. Either way is okay. The legal document or the writ is deemed to be served if the defendant solicitor endorses on the writ the sentence or statement that yes, he has accepted the service of the writ on behalf of the defendant. Okay? And the date that the solicitors endorse on the copy of acknowledged receipt is the date of service. Okay? So the same date that you serve on the solicitors. Now, substituted service, you have to briefly explain the concept. If you answer this question in the exam, you have to explain what substituted service is, but you do not have to go on and lay out 10 examples of how it can be effective, because every case will be different. Right? It can be by newspaper, it can be to the director of the elderly home, it can be to the guardian or guardian ad litem or next friend, etc. Right? So we don't expect you to list out the various examples how substituted service may be effective. Okay, but we do expect you to give sort of the concept. Okay, so where the defendant, where there are difficulties to serve the writ on the defendant, the plaintiff may need to take other steps, and therefore the plaintiff is suggesting to the court, because leave has to be sought first. You can't just raise your hand and say, hey, I think, well, we can't find the defendant, or I have difficulty to serve the defendant on the defendant, so I think I'll advertise on newspapers. You can't just go ahead and do that. You have to seek leave from the court first, and the court will give you directions, or you can propose directions that are subsequently approved by the court, okay, on how to effect, whether you can effect substituted service and how. Okay, directions will be given. So, difficulties to serve on the defendant, then you need to apply and state or tell the court that yes, you need to take other steps that we suggest, which will have a reasonable probability to bring the writ to the attention of the defendant. That leave, application for leave from the court to do substituted service is by an ex parte application, supported by an affirmation. As I said, normally in that affirmation, the applicant's plaintiff would already suggest or propose some directions that the court can consider to effect that substituted service. There is, as with any other ex parte application, there is a duty of full and frank disclosure. Okay. The last point there is just what I said. Mode of substituted service would be given, okay, by directions of the court. And after you effect that, you would have been taken. Let's say, for example, we say advertise 3 days for consecutive 3 days on South China Morning Post and Apple Daily. Okay, if those are Hong Kong and English newspapers in circulation in Hong Kong. Then, after you have done those advertisements, complying with the court order, then service would be deemed effective. Right? It's by compliance of that order given by the court. Sometimes extra information, sometimes the court will give in the directions, or also give you that yes, service will be deemed to be effective after 7 days from the consecutive advertisement on the papers. Okay, so that's how the court sometimes will actually tell you a different deemed effective date, but that's from the court order. How about companies? Okay, personal service on an officer of the company, such as a director. So when you, again, as I said in our lectures, an officer of the company, it's normally not the clerk. Okay, you can't leave it with the cleaner and then say, yes, I've left it with the company. And it has to be a higher ranking officer, which is normally the director. Serve at the company's registered or principal office by registered post or by inserting through the letterbox. For partnerships, because as you know now, it's joint and several liability, right? So remember that, partners? Okay. So you serve on any one of them. It's effective service on the partnership. Okay. Personal service or postal service on one or more of the partners. Now, when we say personal service or postal service, then you comply with the requirements of what we say, right? We're either reading it with the person or comply with how you normally do postal service, right? A registered post or inserting into letterbox as well. Service at the principal place of business within jurisdiction on any person who at the time of service has control or management of the partnership business. Why is that? That's because you've also learned in your business associations law that there can be de facto partners, right? So people who may not be officially partners can have control and management of the partnership business. That is the second point, or the last point there, is to cater for that. Any questions on service? Default judgment. Question 3. How does a plaintiff obtain a judgment in default of AS under Order 13? Can such a judgment be set aside by a defendant? In support of your answer, you should refer to any relevant case law. Okay, so my overall suggested structure would be define what we mean by judgment in default. In particular, judgment in default of AS. So you have to explain the timeline a little bit, right? From the time of the writ. So the nature, the expiration time for AS, and how the date of expiration is calculated. Then you go through the application procedure and the effect of such a judgment. Now I'll come back and, okay, here I'm covering the structure. I'm going to come back and look at a little bit of the meat of the skeleton. Okay, your first part, right? Your first part is about, or my overall structure. One is all about the application for judgment in default itself. The second part of the question asks you, can such a judgment be set aside by a defendant? Can it be set aside? No. Yes. Right? We know that yes, we can. Please do not just answer yes. Okay. You may laugh, but people still do it during assignment and exams. Okay. Some people answer, can such a judgment be set aside? Naturally, you have to tell how. Right? We try to give you marks, you have to give us basis for giving marks. Can such a judgment be set aside, and how? Okay. Yes, can apply to set aside judgment under Order 13, Rule 9 for default judgment to be set aside. Application procedure, inter partes summons, affidavit or affirmation, including reasons for failing to return AS. Now, also, when we say can and how, we still expect you to cover how the court will decide. Okay, every year, whether it's in assignments or exams, you may say, well, but the question wasn't clear about wanting me to explain how the court will decide. Please do it anyway. Okay? Many times the question may look short, but we have to cover what you know here. Same with summary judgments. Right? Before judgment, summary judgment, or security for cause, you have to tell us how the court will decide, what are the relevant principles. Okay? Of course, when you talk about how the court will decide, you will go through the difference between irregular judgments and regular judgments. Right? Remember we agreed that irregular judgments will be easier to set aside. You will, because you need to tell the difference, you have to define irregular judgment, and then you tell how the court will decide. Right? And about regular judgment, also define and how the defendant will need to show merits. It's up to the court's discretion. Whereas for irregular judgment, it's pretty much as of right, meaning almost automatically entitled. Okay. Now, since this is revision, and so tell me, what is the nature of an Order 13 default judgment? It's basically if they fail to file AS. Okay, I'm doing this because I see some people starting to fall asleep as well. But as I told you, this is only the skeleton. So it's failure to file the AS within how many days? Within 14 days of counting from the service of the writ. Okay, don't say SOC. Writ is the most correct answer. Okay, you count from the writ. Okay. The defense may vary depending on whether it's a general endorsed or specifically endorsed writ, but the AS, there's no difference. Count from the writ. Okay. Expiration of time is 14 days from writ. Okay. So application procedure is by, as with most interlocutory applications, is by. What are the documents you need? I've only left you for 1 week. I've only left you for 1 week. Don't make me cry. Okay, so it's by summons, and can I get more information? What kind of summons? Inter partes or ex parte? Inter partes. Okay, it's only when we want to catch people by surprise, like Moreover injunctions, or most injunctions, or if we cannot find the other party. Okay, then we use ex parte. Otherwise, most likely for most of the interlocutory applications we have looked at, apart from enforcement, enforcement is but mostly inter partes summons supported by affirmation, right? If you don't want to remember affidavit, forget affidavit, just say affirmation, that's fine. Okay? So inter partes summons inter partes summons and supported by affirmation. Okay? So not part 2. And what do you have to say about the effect of an Order 13 judgment? If granted, it would have the effect of a it would be as good as a normal or ordinary final judgment. Okay, it can be enforced just like any other judgment. So yes, we have said that default judgment under Order 13 or judgment in default of acknowledgement of service of the writ, that's the full name, can be set aside. We say yes. Okay? Defendant can apply by Order 13 Rule 9 for the default judgment to be set aside. The application would be by, again, inter partes summons, supported by affirmation. Okay, the affidavit would, or the affirmation would detail reasons for failing to return the AS. Even if you are alleging that, no, I did not receive the writ, or no, I was not in the jurisdiction at the time, so it was irregular, you still have to state the reasons, even if it's an irregular judgment. Okay? if the service was defective. Okay? How the court will decide whether to set aside the default judgment. What is an irregular judgment? Now, if you don't come to me, I'm going to come to you to pick on you. This is a revision, and we've only left each other for 1 week. What is an irregular judgment? I'm going to be the devil now. No, first of all, irregular judgment is a judgment obtained but the plaintiff has or has not complied with procedural rules. Not so bad after all. So, not complied with procedural rules. How? Because what is defective? What is defective? Yes. So, the writ is not served properly, or you can say the service was defective. Same thing. Okay? Still okay. So, as a result, the judgment obtained is an irregular judgment. Regular judgment, what is it? Contrast with what we've just said about irregular judgments. For regular judgments, the judgment was obtained by the plaintiff, but this time the plaintiff has complied with all the service procedures, right? And the writ was properly served. So the writ was properly served, so did the plaintiff do anything wrong? Did the plaintiff do anything wrong? No. Plaintiff is okay. So which one did we say is easier to set aside? Irregular or regular? Who says regular? Hands up. Oh, I thought I heard somebody. Irregular? Still only a few showing hands. Okay. Irregular, right? Because the plaintiff did not comply with procedural rules. So for irregular judgment, how will the court decide? The court, okay, the defendant now goes to the court, and the court says, I will grant, or I will set aside your irregular judgment. What's the terminology? As of right. Okay? As of right meaning pretty much automatically. But the court can still decide to attach conditions. Okay, I'm doing revision at the same time, so please try to remember as best as you can. Regular judgments, we defined it already. So why does the defendant need to show merit? Because the plaintiff did nothing wrong. Right? It was a properly obtained judgment. So the defendant needs to show merits whether the defendant has a real prospect of success. When we have terminology like that, just to refresh your memory, do not change the terminology. Okay, if the test is real prospect of success, it is just that, real prospect of success. When we say you do not have to memorize everything in paragraphs or copy and paste, but this kind of terminology or test, okay, you have to use exactly that term. Okay, when we say no arguable defense, we mean no arguable defense. Okay, do not reinvent those types of terminology. Okay, here is a real prospect of success. And for a regular judgment, it really is up to the court's discretion. The court can refuse to set aside. Okay. Anyhow, conditions may be attached if the default judgment is set aside. Okay, some pointers or common pitfalls. Points to note, remember to define concepts such as regular and irregular judgments. Cite authorities where they have been taught or given to you. Okay? Cite authorities whether it's the rule number or the case authorities. Regardless of whether it's an essay or problem question, you need to explain the relevant principle. Just like I said, when you define real prospect, when you talk about real prospect success, explain a little bit. Okay? The depth and length in which you answer the question will depend on the marks allocated. So with any question, just like any other subject, right? But the other subjects most of the time is a whole question. Here, sometimes you're given half questions, right? If you look at your mock questions or the past exam papers, correct? Some of them are just part of an A-B question. So you have to allocate your time accordingly. If it's a half question, then you use less length, okay, and time. Okay, any questions on default judgment? Now question 4 and 11, because they are both about sanctioned payments, I'm dealing with them together. I'm dealing with them together. But we can also talk about the difference about your emphasis, depending on how the question is asked. Okay. With question 4, explain how sanctioned payments and sanctioned offers under Order 22 can assist in settling civil cases. Whereas in question 11, critically explain the operation of sanctioned payments and sanctioned offers as possible methods of settling a civil case in the court of first instance. Now, to me, they're not so different, are they? Okay, the emphasis, the question 11 mentions the CFI, but we've asked you to cite CFI rules anyway, so it's not that much of a difference. This question 11, you can probably add in more flavor of criticism. Do you think it is, for example, do you think it is effective? How, is there any injustice involved? Is that too much undue pressure to settle? Things like that. Okay, so critically explain. Okay, that's the main difference. Okay, so in your overall structure, you would explain the concept of Order 22, sanctioned payment and sanctioned offers. And the purpose, because the question is asking how it helps, or how it helps in, okay, how section SO and SP can assist in settling cases. So the purpose of Order 22 in line with the underlying objectives, including encouraging settlements. Okay, so you go through that. And you may say again, well, it didn't ask me to explain the mechanism, right? But you would, okay? You still would. So you would explain sanctioned payments. Who can make sanctioned payments? Who are sanctioned payments made by? Plaintiff or defendant? Defendants, because they are the only party who would pay, right? Assuming a simplistic scenario, no plan to pay. Most likely, the defendant is the one paying. So the defendant can make a sanctioned payment. Explain the procedure. Okay, explain the procedure of how to make a sanctioned payment. Who can remember how? You would, okay, if you have money, you have to put it into the court. And after you do that, you just leave it there. What do you next have to do? Tell the other side, right? Right? Otherwise, the money is sitting there, nobody knows. So you give notice. I think it's Form 23. Give a notice to the other side using the prescribed form. After that, you would also explain briefly the procedure of how the other side, i.e. the plaintiff, can accept. Accept by also giving notice, right? Saying that, yes, I will accept. Okay? So After that, what happens? Okay. So here we are here. Excuse me. Let's go through the table a little bit later. Okay, here we're looking at how do we make an SOSP, just like exactly the same table as in your lecture. Okay, so after you explain SP, sanction payments, you explain sanction offers. Who can make an SO? Who can make an SO? Both parties. If it is made by the defendant, it would be on a non-monetary claim. Obviously, you remember better when it's a later lecture. Okay, so yes, it's non-monetary. It can be made by the defendant. And the plaintiff, for the plaintiff, is it monetary or non-monetary? Very good. Well, obviously, you're more awake towards the later lectures. Okay, so yes, so the procedure, how can you make an SO? Do you have to fill a form? No prescribed format, but it's normally made by a letter, but you have to include all the contents, all the requisite contents. Right? It's no prescribed form, but you have to put in specific contents, right? Including that the offer is made, the SO is made pursuant to Order 22. Okay. Now, without looking at the table, what would happen if the other side accepts the offer? Let's turn back to the offeree again. So what if the other side accepts the offer? And fill in the form or reply or whatever, what would happen to the case? Yes. At that point in time, the case will be stayed. Okay, stayed. Okay. Now the case will be stayed. What if? And then they'll go through the necessary procedures. It is an SP. After the notice of acceptance is accepted, then the other side can get the money, and so on and so on. Now, what if it's rejected? Proceed with the case and probably to the trial, right? So how do we determine the cost implications? Do you remember? What's the easiest way to express? Okay, what's the difference of the cost implications as in if the judgment is better or worse? So how do you, if the plaintiff, let's say it's a sanction payment. It's a sanction payment. If the plaintiff did better after the trial, what's the cost implications? What's that again? Is there any cost implications? No. Correct. You're correct. No, as in you are correct. Okay, so you're correct. If the plaintiff, if the offeree, in other words, okay, in the exam, if you try to explain, you don't really use offeree, but I'm just trying to let you see. Okay, depending, if you're saying sanction payment, then yes, the offeree would be the plaintiff. If the plaintiff do better after trial, no cost implications, no sanctions. Okay? Remember that word sanctions is almost like a punishment. Okay? So no cost implications. If the plaintiff fails to meet, is there cost implications? Are there cost implications? Yes. Can you name some? Okay, first of all, what is the relevant point in time? We punish the plaintiff for being too greedy. Where do we count from? Remember our timeline? From the that's an okay way to put it. Remember the proper way is, that's in a way is correct. the last date on which the offer of SO or SP could have been accepted. Yes, remember the window of 28 days? Well, pretty much the last day. So you're correct, but the better way to say is the last date on which that SP or SO could have been accepted. Right? Okay, so now, still onward with the structure, then you have to say, go back to the question. Right? How do you, well, some of your subjects in other subjects, some of your other subjects may have essay questions, right? Some of them may. And people ask, one of the questions asked by students normally is, how do we know we're answering the questions? Do you sometimes have that query? How do we know we're answering the question? Well, by going back to the wording of the question. Okay? The question is asking you a question for how SO and SP assist in settling cases. So after you explain the mechanism, you have to bring it back to the question. Okay, you've explained all this. So you will understand also that the implications of acceptance and rejection is very important. Yes? You have to be able to explain them clearly in order to go on to part 4. Right? If you can't explain that there are severe cost implications, you can't put forward your point that there will be pressure, okay, on the offeree side, like plaintiff in the case of SP. Right? There will be quite heavy pressure for the plaintiff to consider a section payment, right? So you talk about, yes, there are severe cost consequences if the party being offered reject an SP and SO but fail to do better. Okay, you can go on and talk about all those implications. Right? It is quite severe, and therefore it encourages settlement. Okay, this is what we went through. I don't think we have to go through that anymore. You think we have to? I think we've answered that already, right? Okay. This is straight from your the PowerPoint from your class. And just remember to state that the offer remains open for 28 days. Okay. Accepting the offer, then filing necessary paperwork, and then get the payment. Okay. Why do I have not much information on this side? I didn't explain during the lecture. It's because it depends what that non-monetary offer is. Right? It may be recovery or possession. It can be other things. So how that the case would wrap up in the case of an SO would depend on what those terms under the SO is or are. Okay, that's why there's not much information here on the next steps. But it is sanction payment is pretty straightforward. It's filing the notice of acceptance and getting the money. Okay, anything here you don't understand? Pretty much okay, right? It's a rerun of the lecture. Okay, as you said, if the offer is rejected, SO or SP is rejected, then the case proceeds to trial, and no disclosure to the trial judge until after the judgment, the main judgment. Okay, just a very quick refresher. If after the trial, the plaintiff beat the SP would have no impact. But if the plaintiff fails to beat the SP, or it's the same amount, the judge will then be told of the SP sanction payment. The plaintiff will be disallowed prejudgment interest on the sum awarded. Again, the milestone date, I shouldn't use milestone because that's another term, but the important date from which those implications run would always be from the last date the SP could have been accepted until judgment. That goes for prejudgment period. Also, the plaintiff has to pay defendant's legal costs on an indemnity basis. We agreed that that would be a wider basis than the normal party-to-party basis. Interest on the defendant's costs, which the plaintiff has to pay, is also on an enhanced interest rate. Enhanced interest rate, because it's about the normal 8%. Also, plaintiff would have to settle his own legal costs, Whereas under normal circumstances, because the plaintiff won, the plaintiff would have got his legal costs paid by the defendant. So it's a double punishment. Okay? Likewise, on the other side, SO, assuming it's made by plaintiff, if it's made by plaintiff, the defendant rejecting and failing to do better, there will be enhanced interest rate on the judgment award. Right? Let's say it's a $2 million loan, that would be enhanced interest on prejudgment interest. The plaintiff's legal costs on an indemnity basis, the wider basis, and enhanced interest rates on those legal costs. And as normal, the defendant would have to settle his own legal costs. Points to note, in-depth discussion of the procedure, especially the cost implications. Okay. For question 11, additional focus would be as a method of settling civil case. You would also, if I were you, I would also try to make some criticism. For example, for me, I would suggest that's quite harsh consequences. Right? This is in the case, for example, where the plaintiff won. It's quite harsh because sometimes there may be other reasons that you reject the offer. Perhaps you remember the plaintiff is penalized for rejecting the ST, even if it's an equal amount. So when you say, okay, the offeree or the plaintiff is being punished or being penalized for sort of too greedy, well, maybe it's not too much. What if it's only a small difference? What if it's the same amount? How it may be hard to judge. It may be hard to say at an early stage, for example, what kind of quantum, okay, what amount of quantum is appropriate, especially earlier on in the case when not all evidence have been reviewed. Okay, so you can throw in some of those criticisms. It doesn't have to be lengthy because a lot of your time or effort is dedicated to also explaining the procedures and the consequences. Okay, but you have to add in a bit of evaluation. Okay, that's what I would say the difference with question 11. Okay, but for either question, you have to cover all the basics. Why don't we cover this question and then let you off for a break? I want you to keep and try to stay with us. Okay? If we need 2 breaks, that's fine. Okay? It's up to you guys. Amendments to pleadings. So let's finish. So this is a short one. I think this is relatively short. Although security deposit is not as short. But let's finish amendments to pleadings, which is question 5A. Question 5A, in what circumstances can amendments to pleadings be made? Now this is a half question. Please note your time allocation. So you would probably explain why there may be reason. Now, the question is under what circumstances can amendments to pleadings be made? You would still be expected to cover the role and importance of pleadings, right? How it's governed by Order 20 and Practice Direction 19.1, and about the circumstances. Right? In terms of the role and importance of pleadings. Now, if the CJR, after the CJR, it's not, the requirement is not so strict in terms of definition of issues, then perhaps amendment of pleadings would not have been so important. But after CJR, the facts, it is very much strict, very strict requirements about facts and issues. that are going to be heard at trial must be defined properly. Okay? If you have not defined or state out the issues in dispute or facts that you are going to rely on, you're not going to be allowed to argue those issues at trial, even if your witness statements have reviewed those issues. There are plenty of Court of Final Appeal cases on that principle. Okay, reasons why sometimes amendments may be needed: examples, new facts, clerical or typos, new evidence that are reviewed after the initial pleading has been prepared. Now, circumstances. The question is not quite very clear about what do you mean circumstances. Are we asking about 1C here, the reasons, or how the amendments can be made? So I would cover both. Okay, even though it's a short question. Now, amendments can be made. Amendments to pleadings governed under Order 20 can be made without leave of court, or with leave of court, or by agreement of all the parties. First pointer there, without leave of court, it can be because it's at an early stage, it's the First Amendment, it's before close of pleadings, etc. Okay? There are circumstances where it can be allowed without leave of the court, and you just have to prepare it, file it, and serve it on the other parties. Now, generally after pleadings are closed, the stage of pleadings are closed, you would need leave of court to amend your pleadings. The test, when the court consider whether to allow the amendment of pleadings, would be whether those amendments are necessary for the fair disposition of the cause or for saving costs. Fair disposition of the cause just means for the just resolution, for the proper resolution of the dispute. Okay, that's all it means. It says fair disposition of the cause, which means it's for the proper resolution or adjudication of the case, or for saving costs. C, it is by agreement of all parties, and that's also okay. Cost implications. Normally, the cost arising out of the amendment would be borne by the party seeking to make the amendment. Must be verified by the statement of truth under Order 41. Okay? Now, do you want a break? Yes, okay. For those that, if there's no other country or no objection, then let's go for a short break. Okay? How long do you want? 10 minutes? Is that okay? Or 15 minutes? It's up to you. 10? 10? Is 10 okay? Okay, who says 10? Who says 15? Okay, so it seems 15.